believe it was January 1st, 2017.
Okay, January 1st, 2017. And did you have a third-party registered agent at that point in time?
It was Dawn Ferreira, I believe, because she's the one that established the corporation.
Okay, so your understanding is Hopner and Associates initially served as the PC's registered agent?
Yeah, until they told me they weren't going to do it anymore.
And when did they tell you they weren't going to serve as your registered agent?
So I contacted Dawn about April, like she said, around 2020, because I had a pending trial in September in this court. And I asked her to prepare documents for me to be used in that trial. And at that time, she told me that she was instructed by Ms. Kellogg not to do anything for me anymore, including accept service for any process. In the past, she would email me documents, and since then, I've got no emails whatsoever from her. And so at that time, just to finish my question, finish my answer, at that time I hired another person to do my taxes, and I assumed that because she specifically told me that she could do nothing more for me, including that service, that I wasn't going to expect anything from her going forward.
So you were instrumental in writing your objection in these proceedings, correct?
What's the question?
Did you participate in writing and drafting the objections filed in this matter before the court today?
No, I've always had an attorney. First it was Radford Smith, and now it's Machanzi.
Okay. Court's indulgence. Are you aware that your objection filed with this court indicated that your objection indicated on page 4, let me see, page 4, that you were told around 2019, you alleged that you were told that RA relationship was terminating at that point in time. So why did that change today in your testimony?
I mean, like Ms. Ferreira, I couldn't recall exactly, but it had been, I said 2019 because my case against her kicked off in April of 2019 when I filed a motion to terminate or modify spouse support. It was after that I called the office so that I can prepare, so I can have my taxes prepared and stuff that I needed for the case, because that's what the court wanted to see, is my taxes.
Your testimony is now April of 2019 is when the relationship, you were informed the relationship would be terminating, is that correct?
It was either from April 2019 when the motion was done, or 2020 like Ms. Ferreira testified. I can't recall exactly, but the call was made in reference to the case that started in April of 2019. That's when I filed my motion. That's when Mr. Smith informed me that he had my taxes prepared for a trial.
And to clarify, I don't believe Ms. Ferreira testified that there was a correspondence in April 2020 concerning the RA. So that's your interpretation of the conversation, but not Ms. Ferreira's.
No, I called her. We talked on the phone.
Okay.
I talked to her directly. And she said, I'm sorry, I'm sorry. She said, I'm sorry, Alex. Tara called. She said not to have anything to do with you anymore. And we can't do anything except service for you per Ms. Kellogg's instruction.
So when did you file any paperwork to change your registered agent?
I did, not until June.
Not until June of when?
This year.
Okay. So if one were to go on the Secretary of State's website January of this year, who would have been listed as the registered agent?
The person that told me that she couldn't accept service for me anymore, Dawn Ferreira. The person that specifically told me that Tara told her not to do anything for me, that person.
sorry, I just noticed something. Can we have Ms. Ferreira log off? Her attorney? It looks like they're still, is that them still logged in?
Remember, we had a sort of a phantom box up there. Madam Clerk, can you see whether or not anyone else is currently attached?
There's 2 feeds for Mr. Nelson.
Okay, I'm
Video
sorry.
and
It's just
audio.
really blurry. I'm
No,
sorry.
that's fine. I think what happened, remember, we couldn't hear Mr. Nelson? So
Yes.
Mr. Nelson has a phone to do audio and a video, right? Isn't that right, Mr. Nelson?
That is correct, Your Honor, so there's 2 of me.
I'm always, it's perfectly fine. We want to make sure that we know everyone who's connected. It's not a problem. So, did you finish your answer, Mr. Ghibaudo?
The only thing I have to add, Your Honor, is that at the time that the corporation was established, I had a different address. In fact, I changed addresses 2 times since then, and I informed them of that.
When you say you're talking about the professional corporation, right?
That's right. It was initially 320 Charleston. That's when they first did my sole proprietorship. I think I did a sole proprietorship in 2016. January 1st, 2017, I was at 320 Charleston. In February, I switched to 703 South 8th Street. And then in July of 2020, I changed to 197 East California. So that's why she would always email me. But the time for this, one time I got sued twice, and she would just send me an email. For this, I never got an email. I checked my records. I checked on the Gmail account that she would always send me information on, including my EIN. Anything I asked for came from Alex at Alex G Law. In this case, nothing.
So, Mr. Ghibaudo, did you present any evidence of that? Hey, she's traditionally done this, here's emails, but there's no email for this?
Unfortunately, we couldn't do that because your client stonewalled with Mr. Reed, made us go through the Discovery Commission, and then when I asked for an extension of time in order to do that, Judge Ritchie denied it. So there's a due process issue that's going to result in an appeal as soon as this case is done.
So Mr. Reed stonewalled your own email? Is that what I'm understanding?
No, Mr. Reed caused
Just answer the question. Mr. Ghibaudo, you're a witness. I know you're an attorney, but right now you're a witness. Just answer the question. Does Mr. Reed have any impact on you pulling up your own emails for presentation today? Yes or no?
I don't know. You're asking me what Mr. Reed can or can't do? I don't know. He's not here. Why didn't you call him as a witness?
Do you have access to your email?
Does Mr. Reed have access to my email?
Do you have access to your email? Yes or no?
Why? Yes, I do. Yes, I do.
Did you provide any of your emails showing past correspondence between you and Ms. Ferrari for today's hearing?
Objection to relevance?
No, I didn't.
Overruled.
No, you didn't.
No, I didn't. You have my sworn testimony as an officer of the court. That's not enough?
Well, you have the sworn testimony of Ms. Ferrari saying she sent it to you, so, what is enough, I guess?
It has a great relationship with Tara and has specifically been told by Tara not to cooperate with me.
So let me
I
go
defy
to...
deny that, Mr. Nelson.
Let me go to Exhibit 23, Your Honor. I believe Mr. Reed indicated that had been provided previously for the prior hearing to the clerk and opposing party. Exhibit 23, Kellogg, or Bates Amps Kellogg 0125 and 0126.
All right, hold on.
I'm not sure if Mr. Ghibaudo...
Let the witness catch up, okay?
I don't have any exhibits.
Well, look, the exhibits were submitted prior to the hearing that was originally scheduled for the end of July. And I try to find them because they were.
I don't have them, Your Honor. I didn't get them.
Well,
I can call my office, but I didn't get any exhibits. I got his pretrial memo, and that's it.
Let's see. Mr. Nelson, I'm going through the electronic exhibit queue. Let's see. Madam Clerk, do you have them handy?
I do. Which exhibit are we looking at?
Number 23.
The 23, yeah.
What is 23? An email?
It looks like a certified copy of the registered agent.
Okay, do you want to, are you able to direct to my printer over here on the side of the bench over here?
No, I'm only able to print out some.
All right.
I can print out there and grab it.
Well, we're not going to be doing that. We're not doing a milk run out in the hallway all day long. July 23rd is when the exhibits were electronically lodged with the clerk. And that's because the hearing was originally scheduled for the 27th. And I suppose, Mr. Nelson, when you assume this case, you just are referring to the exhibits that were lodged by your predecessor, right?
I am, Your Honor, yes.
All right, 23 is, looks like a certified copy of a registered agent change that would be consistent with Mr. Ghibaudo's testimony that the registered agent was changed on June 2nd, 2021, right?
Your Honor,
Correct.
All right, so I'm going to print this and I'm going to give it to Ms. Kramer. And what's the reason why you want the witness to look at it?
I just want to further substantiate that, Hopner, James B. Hopner Associates was the RA until June of this year, and just point knowledge to the fact that Mr. Ghibaudo knew that, and the fact that he waited until June of this year to file it after these proceedings were already in play.
Well, okay, but he already testified. I mean, that's consistent with his testimony that that the resident agent with the Secretary of State was had there until June of this year, right? And it looks like Ms. Kramer's the resident agent.
So,
that's fine. Are you offering 23?
yeah, I'd offer 23.
All right. Do you want to, Ms. Kramer? Are you objecting?
I object to 23. I never received it until just now.
Okay. Well, you did receive it just now, but I doubt that. The objection's noted and overruled. As the court noted, I've got an electric footprint here showing that prior to the evidentiary hearing, what was initially scheduled for the 27th of July, the exhibits were submitted electronically on the 23rd of July.
Your Honor,
And,
I don't understand. We didn't get anything from them submitting them to the court.
I will see if I can.
I'm having my assistant look now, but
Yeah, I know. It's also I don't want to get into the morass of what was or wasn't done. Okay, this is a business record that was created by the principal of the professional corporation, and it is a certified copy from the Secretary of State. Okay, so it's a document consistent with your client's testimony that the resident agent was changed in June. The only information that really has not been established outside of the document is that you're the registered agent now. But the objection is noted, and Exhibit 23 is admitted. And I'll get back into the case file and I'll see if there's some sort of way to explain why you think you didn't get these documents in advance of the evidentiary proceeding. And I'll see if I can answer that. Mr. Nelson, in the meantime, resume your exam with Mr. Ghibaudo.
All right. So, Mr. Ghibaudo, prior to that filing in June of this year to change your registered agent, who performed let me ask you, did you renew your PC every year as required by Nevada state law and pay the license and pay the appropriate renewal fees?
Yeah, I did. I think the last couple of times was done by Mike Patchett, who was helping me with taxes.
So did Mike Patchett and last year you would have renewed it through Mike Patchett, who was helping you with your taxes? Is that your testimony?
He was helping me until I believe it was the beginning of 2020. I can't recall.
Right. Well, was helping you to the beginning of 2020, but it's your testimony that either in April of 2020 or April of 2019, you were advised that Hopner and Associates would no longer be your RA. So if it was April of 2020, who renewed your PC for that year?
April of 2020, I didn't have to renew my PC in April of 2020. It's done at the end of the year.
Okay, so who would have renewed your PC at the end of 2020?
End of 2020? I don't think it's been renewed since. I think I owe that. Somebody's that.
When was the last time it was renewed?
I have no idea. I don't know.
Okay.
All I know is it wasn't them because they told me specifically they cannot help me under any circumstances as directed by Ms. Kellogg, your client.
So when did you retain a new registered agent then?
And didn't we already go over this? I have no idea. Whatever my testimony was before.
So let's talk January of 2021. You heard testimony by Ms. Ferraro that a writ of garnishment was served as they were received service because they were RA for your PC. Do you recall receiving any correspondence from Hopner Associates?
Never.
Okay.
Never. And as I stated before, they would email me documents, and I never received the document from them in January I've never received anything from them since she told me, I'm sorry, I can't work with you anymore because Tara told me not to.
So when did you first hear about the writ in the interrogatories?
When one of the hearings in one of the last hearings in this case, one of the many times that she filed for contempt, even though this court stayed the proceedings, she filed twice for contempt. On one of those occasions when we heard about it, it was even made on the record that we said, we've never heard of this.
Mr. Ghibaudo, is the answer you don't know? Is the answer you don't know? I mean, you're
I'm answering you.
I'm sure
I'm answering
will
you.
police you and give you the top tool that you need, but do you know?
I'm answering you. I told you, yeah. So the last hearing that we had on that,
you're going on a tangent.
if you want to argue, you want me to give me an answer.
Well, let me ask you yes or no, because that's it. Do you recall when you first learned of the writ of garnishment?
Yes, I do.
When did you first learn of the writ of garnishment? What day, what month, what year? That's all I need an answer on.
It was this year, and it was maybe on or about April of this year, one of our hearings, where it was mentioned, and we made a record at that time.
Your Honor,
I'm answering the question.
Your Honor, I asked specifically for a year.
Mr. Ghibaudo, you know better. This is a cross-examination or an examination of a party opponent, and you need to listen to the question and just answer the question, okay? After he's finished, you know that Ms. Kramer's going to ask you questions, and that would lend itself to being able to offer the type of answers that you're giving. So I took your answer to mean that you're not sure, but you think it was April of this year, right?
I'm pretty sure it was April this year, one of the last contempt hearings that we had, yeah.
Okay, next question.
So, Mr. Ghibaudo, when you learned of that, do you recall writing a correspondence to Mr. Reed, who was Ms. Kellogg's attorney at the time?
Yes.
Can I direct the court's attention to Exhibit 18, Bait Stamps Kellogg 0078?
All right.
I object to this on.
Well, I don't know. Are we talking about 18, the exhibits that have been marked for identification?
Just the Kellogg Bait Stamps 7-8. I don't need to go into the 7-9, just 7-8 is all I'm looking at.
All right, so look, I'm trying to manage this ridiculous situation in which we have counsel for the professional corporation and Mr. Ghibaudo saying that they don't have exhibits that were lodged with the court. I'm going to print them out and I'm going to give them to her. and I'll consider objection. But what's been marked for Exhibit 18 is a letter that's apparently on Mr. Ghibaudo's letterhead to Mr. Reed, and it is, that's just the first page of the exhibit. The letter, from what I can see, just looking at it quickly, isn't even really dated.
Your Honor, if I can correct the record, Your Honor, I was texting with my assistant, and apparently these exhibits got emailed to her directly instead of being served, and so when she was out with COVID,
Yeah,
we didn't get them.
that's
So
fine.
that's why I now have them on my email.
All right, great. I don't have to print them every time?
Yes, Your Honor, that's
All
what I
right,
was
so,
trying to tell you, sorry.
Mr. Nelson, I'm in Exhibit 18.
Yes.
You want the witness to focus on the first page of Exhibit 18, which is a letter that starts Chris, right?
Yes, Your Honor.
What do you want to ask him?
Your Honor,
Obviously, it's,
I object to this exhibit on grounds of authenticity and hearsay and the fact that they
It
cut off
hasn't
the
been
top
offered.
of
Why
the
don't you
email,
save your
there's
exhibit?
no
Why don't
date.
you save your objection to the time that it's offered, please, okay? What's your question, Mr. Nelson?
well, I wanted Mr. Ghibaudo to actually indicate whether he recognizes that and would have written that.
I don't have it in front of me.
It's-
I'm in my car outside of North Las Vegas Justice Court.
Okay, again, Mr. Nelson, as a matter of context, okay, I mentioned this when we were going over the record. In the initial motion, there's exhibits, and there was a reference that on March 17, 2021, the professional corporation requested additional set of garnishment and rods, and an additional was provided. That was Exhibit 8 to that filing, March 17, 2021. This letter is not dated, which is interesting, that a lawyer might write a letter that's not dated, but it is a first page with a control number 78. The balance of the exhibit is what is described as the it's a district attorney letter, April 13, 2021, right?
Correct, Your Honor, and again, I'm not looking to do.
So the general idea, whether it's end of March or April, this is the time frame that Mr. Ghibaudo remembers. That would be consistent with this record, right? Mr. Ghibaudo, how am I going to insist on an answer from you as to whether or not you wrote a one-sentence letter to Mr. Reed? It said, Chris, we never received a writ of garnishment. We became aware of it because Ishii mentioned it. I presume that's in the context of the settlement conference that you guys have been doing. If you can send it to me by email, I will respond. Regards. That's it.
That actually, I recall now that's exactly when we learned about it, was when we were doing a settlement conference with Ishii Kunin.
Right. Which
After that, I came back.
That was alleged in the initial motion, and in a perfect world, you would have reviewed the proposed exhibits. They've marked for identification a letter that you purportedly sent to Mr. Reed in that context. I read the entire letter. Can you answer the question from Mr. Nelson as to whether or not this is a letter that you sent?
Your Honor, I object to this because they cut off the top. It's not a letter. It was actually an email. And so they cut off the header information, and so it's not a complete record.
Well, again, I would love to know that, except the fact is that you were provided this prior to the evidentiary proceeding, which a twist of fate gave us an additional two or three weeks between the time this case was originally going to be set and today. And I don't know that it's material, except that it's kind of, I don't know if it's material. Is it really material whether or not he found out on March 17th or at the beginning of April, like you said? I don't know. But it sounds like the witnesses testified that the allegation in the motion, which was that there was a dialogue about the writ around the time of the settlement conference that took place in around March, resulted in a communication asking for information, right? And now we wasted 5 minutes walking around this thing because we have a witness who's in a car who doesn't have the exhibits in front of him. We had counsel who had COVID in the office and doesn't recall getting these exhibits and hadn't reviewed them until right now. And I've got a copy of the letter in front of me and trying to determine whether or not we can get a cogent question and answer
Well,
related
Your
to it.
Honor, this.
And Your Honor, may I speak?
That's neither here nor there. Mr. Nelson, can you frame a question under this circumstance that would make the point you want to make?
Okay. And Your Honor, just for clarification, I believe Mr. Reed cut off Ms. Kramer's right, cut off the timestamp. If you look at exhibit, the date stamp 7/7, I believe that's continued correspondence. And again, I wasn't saying it was a letter written, I was just saying correspondence. But Mr. Ghibaudo, do you recall on or around March of this year writing correspondence to Mr. Reed concerning the writ of garnishment?
I mean, I've written him a lot of correspondence. We had multiple correspondence. I don't know which one you're identifying.
Specifically, do you recall, and I know you don't have it in front of you, but a correspondence on that shows a logo, Alex B. Ghibaudo, Chris, we never received the writ of garnishment. We became aware of it because Ishii mentioned it. If you can send it to me by email, I will respond. Regards, Alex. Do you recall corresponding with Mr. Reed along those lines?
I mean, there's been so many correspondence between me and Mr. Reed that I honestly don't recall.
Okay. So to that end, do you recall requesting to have the garnishment sent to you via email?
I don't recall that.
Your Honor, I understand you're probably wondering what the hell I'm doing here. I think, I believe the January 12th service was perfected and done appropriately, but, there's a little second half clause of NRCP 5 concerning electronic service, which I think is really critical, and Ms. Kramer has failed to look into. I believe it's important that we have Mr. Ghibaudo speak to this document because of that argument. So if he doesn't recall, I would ask to move it and enter it, and if there's objections, I'll continue to lay foundation, I guess. But I would ask to enter.
I never accepted service by email. There's no written acceptance of service by email between Mr. Reed and I. We would exchange emails.
I'm not.
But there was no written.
Excuse me. You're a witness that you can have cross-examination. That's it.
Yeah, look, stop. Mr. Ghibaudo, you're a witness right now. I don't want to hear argument from you, okay? I'm trying to understand what Mr. Nelson's point is. This particular letter, if it's accepted or is an invitation to receive something by email, can you send it to me by email? But it does not establish whether an email was sent or what was sent or anything else, right?
Well, actually, Your Honor, I believe that's undisputed by Ms. Kramer's objection. And she says, it was sent by email, not e-served. But my argument is if you direct your attention to NRCP Rule 5, B, subsection 2, subsection E, service, a paper served under this rule by submitting it to the court's electronic system, skipping along, or sending it by other electronic means that the person consented to in writing.
Okay,
So, Your Honor,
so you want this exhibit to be entered into evidence to support some sort of argument that it constitutes consent for an email service, right?
but if entered, Your Honor, it states, please send it to, please email to me and I will respond. And it is undisputed that Mr. Reed actually did email those, it's in their own objection.
That's not into evidence yet. But
Well,
what's in dispute and not in dispute is, we could argue about that all day. But Mr. Ghibaudo, or Ms. Kramer specifically, Exhibit 18 is offered into evidence. The first page, which is the one objection you stated, is that it doesn't contain the timestamp on the top of the facts. Do you have another objection that you want to state?
Yes, Your Honor, I object that the record is not complete, so it's incomplete. I object to authenticity, and I object to hearsay.
All right, the objection's overruled. The first page of Exhibit 18 is admitted.
So Mr. Ghibaudo, you reached out to Mr. Reed informing him that you became aware of the writ on around March or April of this year. Did I hear you correctly? Yes or no?
On on or about March or April? No, I don't know if it was on or about March or April. I don't have the exhibits in front of me.
Okay. To your knowledge, did Mr. Reed's office ever send you via email the writ of garnishment and the affidavit of writ of garnishment?
I don't recall that.
Okay. Are you aware that your attorney wrote in her objection that they were emailed to you?
I don't recall that either. I get a lot of emails. If my attorney says,
Alex, stop talking. I object to that because he misstates what I'm talking about when I'm saying they weren't emailed. Because when I wrote the objection, they weren't emailed by the registered agent who had terminated the relationship. So that's what I was referring to. So I've got to counsel not mistake my filings.
He's not asking whether or not you agree that he's asking as a matter of fact, did he receive the writ by email?
But he just said that I said it was email.
Well, no, I think that look, he has a reasonable basis to ask the question in that way because of the filings that have been made in this case as it relates to defenses that have been asserted. There is a defense in this case that the manner of delivery of the information was not pursuant to the statute. That's what he's talking about right now. And he has a basis to ask the question that way because you made filings on behalf of the professional corporation, Mr. Ghibaudo, which suggested that he did in fact receive the papers, but not pursuant to the, from the resident agent or pursuant to the statute. He's asking the question specifically about whether Mr. Ghibaudo received in March or April a copy of the documents from Mr. Reed. And Mr. Ghibaudo answered he doesn't recall. So that lets Mr. Nelson know what he has to do as far as proving that or not proving it.
He's also misstating the context of my filings.
Whatever, it's neither here nor there.
Well,
His question is not.
Your Honor, I'm gonna.
Yeah, go. Mr. Nelson.
Your Honor, just for clarification, on Ms. Kramer's own pleading, because I don't want to be accused of writing anything. It was filed April 22nd, and it is the Consolidated Opposition of Plaintiffs' multiple applications and motions for entry of judgment against Garnishee, Alex B. Ghibaudo, PC, counter motion to sanction plaintiff and her counsel for attorney's fees and costs. I'm not putting words in Ms. Kramer's mouth. I will direct, because I want to be page 6 of that pleading, line 8. This is Ms. Kramer's pleading, not mine. The first time Alex actually learned of the interrogatories was during mediation with Israel Ishikunin. After learning about them, Alex emailed Mr. Reed and asked him about the interrogatories. Mr. Reed was at that point on notice that Alex had not been properly served. He emailed the interrogatories to Alex but failed to properly serve him.
Yep, lines.
So my question is,
yes, so I know why you asked the question the way that you did. You didn't make this up out of thin air. You didn't mischaracterize Ms. Kramer's position as it relates to her written papers in the case. She raised a defense in the opposition, one of the reasons why we're having the evidentiary hearing, about whether there was proper service or whether it matters the manner in which she received the service. We've had Mr. Ghibaudo testify that he found this out around a settlement conference. We know from other evidence the settlement conference occurred around March or April of this year. We have a letter that's been admitted into evidence over their objection that he asked Mr. Reed for a copy of the paperwork, and we have a filing that was made prior to the hearing on June 2nd, the opposition to the motion, which says that the documents were sent but not properly served. Okay? And so we have now Mr. Ghibaudo's testimony that he doesn't recall whether he received them electronically, and I'll sort all of that nonsense out. Okay? Next question.
Mr. Ghibaudo, on that same pleading, the consolidated opposition to plaintiff's application of motions for entry of order and judgment against Garnishee, defendant Alex B. PC, counter motion to sanction plaintiff and her counsel for attorney's fees and costs. Did you, on or about April 22nd, April 21st, declare under the penalty of perjury that the foregoing was true and correct? And direct your attention to page 12 of your own pleading, if you don't recall.
I don't have it in front of me. Machanzi wrote everything. He showed me everything, and I signed off on everything.
But you
And by the way, the email would go to Machanzi, not me.
Well, again, let's not confuse the situation. You've been asked a specific question. Did you sign a declaration at the end of the motion at page 12 of 14 to the opposition that was filed on April 21st? I think your answer was yes, was it not, Mr. Ghibaudo?
Yeah, Your Honor, everything that was written on my behalf, I reviewed and I signed.
He didn't ask you who prepared it. He didn't ask you whether you liked it or didn't like it or whatever. He just said, did you sign it? The question is yes or no. Go on, Mr. Nelson.
And in that same, on page 11, as part of the affidavit you signed on that same pleading, you said you had read and reviewed said pleading and they're true of your own knowledge except for those matters on information belief. But as those matters you believe them to be true. Do you recall signing that?
I don't recall, but if it, my name, yes, I guess, yes.
Okay. So let me ask you again, did Mr. Reed's office email you the interrogatories in the writ?
I don't remember if it was me or Machanzi. I mean, Machanzi was my attorney of record. But read again what exactly it says on the affidavit. I don't have it in front of me. Read exactly what point you're trying to make. Read it.
Well, okay. I direct the court's attention and parties' attention to page 11 on that same pleading filed by Ms. Kramer, declaration of Alex Ghibaudo, Esquire, page 7, or sorry, paragraph 7, line 20 of page 11. I have read the foregoing consolidated opposition to plaintiff's applications and motions of entry of order and judgment against garnishee defendant Alex B. Ghibaudo, PC, counter motion to sanction plaintiff and her counsel and for attorney's fees and costs, comma, and know the content thereof, that the same is true of my own knowledge except for those matters therein stated on information and belief as to those matters I believe them to be true.
Okay, so you're asking me if I signed a boilerplate affidavit? Yes, I did.
And you signed it under the penalty of perjury, correct?
Yes.
Okay. But now you're saying you don't recall if you were emailed the writ and the interrogatories by Mr. Reed, correct?
Now, months later, I don't remember. But if I said at that time that it happened, perhaps it happened. I don't know. But you're asking me now in August. I've got a lot of cases, Mr. Nelson.
I understand. Do you recall in correspondence to Mr. Reed's indicating that if he sent those by emails, you would respond? Do you recall that?
No, I don't.
Okay.
The Machanzi was my attorney and has been my attorney.
Well, she was a registered agent as of, for the corporation. She was not the attorney at that time, was she? Was she the registered agent?
Why would Reed send me emails when I have an actual attorney?
So you're indicating that Mr. Reed would have known Chancey Kramer was your attorney for Alex B. Ghibaudo, PC, on or around March of 2021?
What?
See, I get this is kind of confusing. It is really. I'm not trying to pull any tricks, but the interrogatories were served on your professional corporation. Were they not?
No, they weren't. I never got it. No. I never
You got it by
received
email, correct?
anything.
You may have gotten it by email sometime in March or April.
I
But now
cannot
you're saying-
recall, sir. I told you I don't remember, but you have my affidavit. Please just move on. You're wasting my time.
Okay. So assuming you were emailed in March of 2021 the writ of garnishment, did you ever respond?
No, I didn't because it wasn't properly served on me. It was emailed to me.
Even though you acknowledged you would respond if you were emailed the interrogatories and the writ.
I don't know if I just said that or not. I don't remember. I don't have it in front of me. And even if I did, so what? I never got served properly. You know, there are service rules that should be followed.
have no further questions for this this witness.
Okay, Ms. Kramer, your witness.
Thank you, Your Honor. Alex, did Miss Reed, or did Mr. Reed or Tara provide you a $5 fee for the garnishment?
No.
Okay. To your knowledge,
No.
did they provide a $5 fee to the professional corporation?
No, they did not.
Okay. How were you introduced to Hotner and Associates?
By Tara.
And did you have any kind of conversation with Tara about why she would recommend them?
Because they would do anything that we asked them to do, that they were dirty.
Okay. And did she give you any idea of how long she had known them?
She told me she had known them since the 90s.
And
That she had a special relationship with Hopner.
and what about her family? Did she indicate that her family knew them?
She did.
Okay. And, you know, your professional corporation had been sued before, correct?
It was.
And what were they sued for?
One time was a process server and another was a disgruntled client.
Okay. And was Hopner and Associates served in both of those cases?
They were.
And did they notify you of service?
By email.
And did they attach the documents in the email?
They did. The entire document.
Okay, and you heard Ms. Ferreira testify that if it was more than 1 or 2 pages, she would mail it instead of email, correct?
Yeah, I heard her. She lied.
Okay, and so when you got sued, was the complaint and summons that you were served with via email from Hopner and Associates, was that 1 or 2 pages?
No, it was a full complaint with the summons and everything else that comes with a complaint. Like the initial complaint from the process server was at least 6 pages long, and then the one with the one from the crazy litigant was even longer than that.
Okay, and both times Ms. Ferreira made sure that you received an email copy of that, correct?
She did. Everything between me and her was done by email. She never mailed me anything.
Okay. And now you were questioned about why we didn't produce emails from your past contacts with Ms. Ferreira, correct?
I'm sorry, I couldn't hear you.
You were asked how come you didn't provide emails showing past email contact with Ms. Ferreira, correct?
Yes, that's right.
Okay, did any of those former cases involve Tara Kellogg?
No, they didn't.
Okay. Is there anything else you want to testify to?
No, just that everything that Ms. Ferreira said was just a lie. She completely lied. She, in fact, told me directly by phone when I called her and asked her to prepare taxes preparation for this case that she was directly contacted by Tara herself and told not to cooperate with me under any circumstances, to include not serving me any papers. That's what she told me, and that's when I hired another bookkeeper.
So after she told you she was not going to accept service anymore and not going to represent you, why didn't you change the Secretary of State's website?
I mean, I don't know. I wish I had. I mean, I was busy dealing with her, constantly harassing me online, on motions. We had a case that we were pending, and I just assumed that her refusal meant I wasn't. There was nothing more to do. She straight up told me I'm not going to do anything more.
Okay. Thank you. I'll pass the witness, Your Honor.
Mr. Nelson?
A couple quick redirect. Yeah, very briefly, Your Honor.
Yes.
So did Ms. Ferrara ever email you about anything related to Alex P. Ghibaudo PC?
Yeah, she did.
Okay, and those haven't been presented today, correct, by your counsel?
No. Not that I know of.
And you mentioned
And we were denied due process.
Yeah, you mentioned you moved. When did you last move, change addresses?
July of 2020.
July of 2020.
After she told me she wasn't gonna help me anymore.
But yet you didn't substitute any registered agent until June of this year, correct?
That's right.
Okay. No further questions, Your Honor.
Your Honor, I have a follow-up question.
Okay.
Alex, as of July of 2020, when you moved to 197 East California Avenue, was Hopner and Associates authorized to accept service on your behalf?
No.
I have no further questions, Your Honor.
So Mr. Ghibaudo, they weren't, you said Hopner and Associates wasn't authorized to accept service. And what was the basis for that?
We had a conversation and she said that she wasn't gonna accept service from me anymore. And so I wasn't gonna authorize them to do it because she specifically said Tara told her not to cooperate, not to do anything. And she had previously told me that's a dirty firm, that they'll do anything that we ask them to do. They'll file whatever taxes we want.
So that's not in writing, there's no correspondence concerning that, just the he said, she said, is that correct?
Yeah, well, your client doesn't have the greatest credibility, so I'm an officer of the court.
I'd say that cuts both ways though. No further questions.
Okay, anything else? All right, good. We went past the normal time that we would take a break because I wanted to make sure that Mr. Ghibaudo's testimony was finished before we did take a short break. We got about an hour left. Who's your next witness, Mr. Nelson?
I'm trying to get the constables, I'm not sure if they're in the breakout room, they've had trouble getting online.
Is the person that you're going to call this T. Martin, the guy that did the affidavit of the Ritchie?
Yes, it should be.
All right, so we'll take a break for, please log back on no later than 5 minutes after 11.